I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
Good day. We are delighted to be here again with another segment of the Chief Justice's Commission on Professionalism's historical video series. And we're particularly delighted today to be talking to former Chief Justice James G. Exum, who now lives in Greensboro and practices law with the law firm of Smith Moore. Jim, glad to be with you today. You grew up in North Carolina.
That's right, Tom.
Tell me a little about growing up in eastern North Carolina and the environment that you found there in your early years.
Well, I grew up in a small town, Snow Hill. Snow Hill was the county seat of Greene County. When I was growing up there, it was sort of known as the smallest town in the United States with electric lights, waterworks, and professional baseball.
Ah.
We actually had a professional baseball team, part of the Coastal Plain League, which was there until the First World War, and then it disbanded. Snow Hill was a great place to grow up. I always said that Snow Hill is sort of the hub of eastern North Carolina because it sits right in between Kinston, Goldsboro, Greenville, and Wilson. And these towns sort of surround it. Great town to grow up in. I like small towns. It was a place where everybody knew you, had family, cousins, friends. But that's where I got started in life, Snow Hill.
And your family had a small business, or a business in Greene County.
Well, it was a small business. My dad in 1948 began a venture which later turned out to be Happy Jack Dog Remedies. He had invented a mange medicine for dogs. Dogs were a hobby of his. He was a great beagler and always had a pack of beagles. And some of my fondest childhood memories are hunting behind his pack on Saturdays. He loved his dogs. Sometimes we accused him of loving his dogs more than he did his children. They always got first dibs on medical care. If anything happened to one of his dogs, he'd rush the dog to the vet. If anything happened to his children, he would say, "Oh, you'll be all right, give him an aspirin." But from that hobby, grew the business. He started the business, Happy Jack Dog Remedies, with his mange medicine, which he did invent. Came from an old formula that dog lovers in the area used, and that Happy Jack Dog Remedies later expanded and became a successful enterprise for him and my two brothers who later joined him in the business.
And you know, a lot of people whose family had a small business in those days would have maybe gone away to college, maybe not, but likely would have gone back home and gotten involved in that business. You chose a different path and decided to go to law school. What led you in that direction?
Well, I went to University of North Carolina first. I was fortunate to get a Moorhead scholarship to go to the university after I graduated from Snow Hill High School. And at the end of my college, Daddy had the business up and running at that point and was doing fairly well. I wasn't quite sure what I wanted to do. I was thinking about several professional or vocational ideas. One was the law. I was thinking about journalism, thinking about the ministry. And one of my deans, Dean Carden Spruill, I'll never forget him, came to me one day on campus, I think in the spring of my senior year, and said, "Hey, there's this great scholarship that NYU is offering, pays you full way. You get to live in New York for 3 years, go to school." And he said, "Why don't you apply for it?" So I did. I applied for it, the Root Tillon Scholarship, and won the scholarship. And that's sort of how I ended up in law school, not really knowing at that time what I would ultimately do, but knowing that law would be a good sort of continuation of my liberal arts education and a good chance to spend some time in the big city. And so I made that decision to go to law school.
And so Eastern North Carolina to Chapel Hill to New York City. When you were in law school, I would bet a lot of your classmates looked to stay in the city or in the Northeast and join law firms up there. You came back to North Carolina. Why do you think that is?
Yes, the law school in those days, and I think probably still does, it sort of encourage their graduates to stay in the city and practice. I actually had an offer from a Wall Street firm, Wilkie Farr, Gallagher, Walton, and Fitzgibbon, to join them as an associate when I graduated. I also had an offer to come back and clerk for Justice Emory Denny on our North Carolina Supreme Court. And so I was just weighing those two things. Do I stay in New York? Do I come back home? And I finally decided that North Carolina was where I belonged. And really at that point, my ideas were, I want to be a country lawyer. I want to go back home. I want to go back to Snow Hill. I'll take this clerkship with the court for a year, sort of get back into the North Carolina legal scene, and probably after that, I'll go back to Snow Hill and open up a law office. That's what I had in mind at that time.
And tell us about your experiences as a clerk with the
Great.
Supreme Court. That's your first exposure to
That was my first
Supreme
job at a law school. Justice Denny was then the senior associate justice on the court. Great man, great lawyer, very keen legal mind. We also had a really good bunch of clerks. Lewis Meyer was in that class of clerks, and
who later joined you on the
Lewis
Supreme Court.
later joined me on the Supreme Court. Lewis and I became really good friends that year. This was in 1960. Bob Jones from the western part of the state, Jimmy Love from Sanford, who later, he and I were later in the legislature together. But that was just a wonderful year to come back and work with the state's highest court, to help Judge Denny get his work done. He worked very fast, and in those days, basically what the clerks did was help the judges write their opinions. We would do legal memos, and I would hand them to Judge Denny. Sometimes he would already have the opinion written before he got my memo, but we discussed the cases, and it was he was really one of my first mentors in the law, and he taught me things like, thoroughness, careful research, reading cases with paying particular attention to the facts of the case and what the court actually does, and he was very helpful in that early job.
And that, I think, was your first real exposure to appellate practice in the appellate courts, and
right.
Of course, later you would come back there.
We got to read the records. In those days, the records were mimeographed, small little things about like this, and we would read the records and read the briefs, and I really enjoyed picking up the records, and because to me they were like little vignettes, they were like little stories about people, and I realized soon that the law really does affect people. We're not just up here spouting legal ideas and legal principles. What we're doing is making decisions that have a profound effect on the lives of these litigants that are coming up here with their stories to tell. And that was one thing that entered my mind at that fairly early stage, and that Judge Denny and I used to talk about.
And when you left the Supreme Court, you did not go back to Snow Hill. You came to Greensboro and joined a law firm in this city. What drew you there?
I did. I really had thought I was going back to Snow Hill. I had discussed renting space there on the main street of Snow Hill. This was in the spring of my clerkship year, which was 1961. And out of the blue, McNeil Smith called me. Mac Smith, we called him, was then a senior partner in the firm here of Smith, Moore, Smith, Shell, and Hunter. And Mac asked me what my plans were, and I told him, and he said, well, we'd like for you to come to Greensboro and start out with us as an associate. I demurred at first and said, I thought I really ought to go back to Snow Hill. And Mac was very persuasive. He said, well, let me just suggest this, Jim. He said, Snow Hill will always be there. You can always go back. If you come up here and you don't like it, you can always go back to Snow Hill. This is not anything set in stone. Just come up and try it with us. And so he talked me into coming, and I came up and joined the firm that summer, the summer of '61, as an associate, and really liked Greensboro. Greensboro was a very open town. People were very friendly. They accepted newcomers. I felt very welcomed here. The firm was a great place to work. Interestingly enough, it was then the third largest firm in the state.
It had how many?
17 lawyers.
17 lawyers.
But the work was interesting. I had plenty to do right from the beginning, sort of hit the ground running, and soon had my own cases and my own files, and liked the practice. We had a great group of people to work with. Mac Smith was really one of the leading litigators in the state, as well as Beverly Moore, who was another senior partner. Steve Milliken was very active, Bynum Hunter, and that was the niche I got into, was litigation, and really enjoyed that. Tried some fascinating cases with both Beverly and Mac. Learned to be, I think, a pretty decent trial lawyer. Actually argued some appeals. I think in the first 4 or 5 years of my practice, I had appeared in the Supreme Court of North Carolina 5 times, arguing appeals, which is not, young lawyers don't get to do that much today. But I was in court trying jury cases, And to get to try them with top lawyers and really great litigators like Mack and Beverly was just a thrill.
And there were some great litigators that would have been on the other side of you in some of those cases.
We were fighting good lawyers always on the other side. I remember one of my first cases, it was Mack's case, but he asked me to help him with it, and it was a wrongful death case. It was in the federal court in the Middle District in Durham, and Judge Johnson J. Hayes was the trial judge. He was a great judge, a great man, and appearing before him was a real privilege. I'll never forget the case. We tried it for almost 3 weeks before a Durham County jury, and as I said, it was a wrongful death case, and our client was named Real Kill. Real Kill had made this insecticide, and the claim was that it was a tragic case. A young student at the University of Chapel Hill had used Real Kill, and the claim that the claim was that it caused a very serious blood dyscrasia, which later led to his death. Tragic case, but defending a wrongful death case with your client named Real Kill, I thought was a pretty substantial hurdle, but we didn't feel like there was any negligence on the part of our client, that we felt like the product was safe, and we did get a favorable jury verdict in our favor. And that was a thrill. Mack let me examine some witnesses. I took some depositions in the case, made a jury argument, and that was one of my earliest recollections of some fairly substantial litigation.
So you practiced law, got involved in the community, and at some point decided to run for the General Assembly.
Did practice law. 1966. There was the General Assembly had created a new seat. Guilford County had 5 seats. We then had 6, and so there was a vacant seat. I talked to the firm. I thought at the time too. One of my early ambitions, one of the reasons I wanted to go back to Snow Hill was because I thought I wanted to get into politics and to be a politician. And so the opportunity came to run for a vacant seat in the General Assembly. Talked to the firm about it. They were very supportive. And so I put my hat in the ring, and one of my opponents, my main opponent as it turned out, was Henry Fry. Henry and I were sort of vying for that 6th seat. And we had a great campaign, my first campaign. Worked hard, got all over the county, shook a lot of hands, met a lot of people, really enjoyed the campaign, and barely eked out Henry. We barely won, got that 6th seat. So I served in the 1967 General Assembly.
And then, and Henry, of course, later joined you also on the Supreme Court.
Well, Henry, it was at the end of that session, David Britt was the Speaker of the House in 1967. And at the end of that session, Governor Dan Moore wanted, the legislature had created the new unified court system under David's leadership. And so...
and this came from the so-called Bell Commission.
The Bell Commission.
Right.
And sort of unified our court system. The 1967 General Assembly put the final touches on that bill and created the Court of Appeals. And Governor Moore, and we created a number of additional Superior Court judgeships. Governor Moore had the opportunity to appoint all 17, 18 Superior Court judges. He appointed all of the initial members of the Court of Appeals, including David Britt, and he appointed me at the end of the session, along with a lot of others, Bob Collier, Lacey Thornburg, Tom C., to the Superior Court bench. I had not, the interesting thing about that appointment, as far as I was concerned, was that I had not supported Dan Moore when he ran for governor. He had run against Rich Pryor, Rich Pryor was a neighbor of mine in Greensboro and a good friend, and so I had supported Rich, and Governor Moore knew that. And when he called me into his office toward the end of the session, he said, "I need to talk with you about something." I went over. I thought he was going to talk with me about some legislation. And when he told me that he wanted to appoint me to the Superior Court bench, to a newly created judgeship here in Guilford County, I mean, I was totally taken aback and surprised. And I think my first words to Governor Moore were, "Are you serious?" I was relatively young, had only been practicing law about 6 years, and didn't really feel that comfortable that I was ready for this job. I told him so. He said, "Well, you let me be the judge of that." You know, he said, "I'd like to appoint you." Of course, he said, "Go back, talk to your law firm and your family, and come, let me know what you want to do." And so that's what I did, and they were okay about it and decided I would take the job.
And so that started in
I
1968?
started in my judicial career in 1967, a Superior Court judge here in Guilford County. Didn't know whether I was even able to do it.
And you were 34?
31.
31.
Yeah, and was very nervous about it, very uneasy about it. And my first court week was in Mecklenburg County, a motions week, and that was very intimidating in itself. But you know, what I found was that I had great help from my colleagues. The other judges were readily available to me if I had questions. The lawyers were very helpful, you know, and I found that early on that really a judge's basic job is to listen, you know, just listen to the lawyers, and I tried to do that. The lawyers were very fortunate. We had a good bar in those days. It was much smaller than it is now, but most of the lawyers that appeared before me were conscientious and competent, and they were very helpful to me. And so I would listen and found one of the things I really feared at first was a paralysis in my decision making. You know, whether I said, you know, what if I just can't decide? What if you can't decide these things? You got to decide. That is the key duty of every judge, is to decide the case. And I feared, what if I can't decide? Well, some of the cases were hard to decide, especially some of the motions. Jury trials, as you well know, were relatively easy because we allow the juries to make all the hard decisions. But when you had motions, and sentencing was a particularly troubling type of decision that we were called on to make. But as I got into it, I got more comfortable with it, and it turned out that I was able to go forward, make a decision that I felt like was, you know, passable and rational, and that I felt comfortable with. But as a trial judge, the toughest thing I had to do would be criminal sentencing. That was just something I never got comfortable doing, but you know, we had to do it. So you made the best. And in those days, as you know, we didn't have guided sentencing. We didn't have structured sentencing. Judges were sort of left in an unfenced field. They the range of sentences in many cases was, you know, 2 years, 3 years to life, or 10 years to life. So you could, and I think today I'm very glad to say that judges do get more guidance and they do get more help. And thanks in many ways to the good work you did in persuading the legislature to adopt a structured sentencing system, which I very much supported. In fact, while I was on the trial bench, I wrote a piece that was published in North Carolina Bar Notes suggesting that the General Assembly needed to get more involved in the sentencing process and needed to give the judges more guidance
Well, and then with your work in the ABA, you also really were a leader in the Criminal Justice Standards Committee of the ABA and looking at a so-called guided discretion system. And
yeah, much later on.
While you were on the Supreme Court.
When I was on the Supreme Court, I got active in the American Bar Association and chaired the ABA's Commission on Sentencing. And we did come up with a sort of structured sentencing idea that North Carolina adopted in many ways. But my thoughts about that really began as a trial judge back in the early 70s as to the need for the legislature to have more input into criminal sentencing.
Well, one of the features of the trial bench when you were serving, and you served about 8 years or thereabouts before you ran for the Supreme Court, and one of the features was a pretty broad rotation, that is moving around the state from county to county. It's in our Constitution there, most would argue, to ensure judicial independence. How do you feel about that rotation system? Is it something we still need today, or?
Well, yes, we rotated. In those days, the state was divided into 4 divisions. Fortunately, Greensboro was fairly centrally located, and most of my court was within a day's drive, so that I could come back and spend the night most of the time at home, which was good. But I've always thought that rotation has some advantages in the sense that when you move into a county where you don't reside and don't deal with the lawyers every day, it does take the judge away from you being too tied in with the local bar, local politics and that kind of thing. But I grew to think that we were overdoing the rotation idea, and that it really creates great inefficiencies in our judicial system because what it means is that the control of the calendar is really largely left to the litigants and their lawyers, because the judges are not there to supervise the cases. And so I began to feel and began to believe, and I still hold to this belief, that we needed to greatly reduce the amount of rotation that our trial judges have to do. And you know, what the system that I would like to see us go to administratively is to give the judges greater control over the cases that are filed. What I would like to see is that when a case is filed, it's assigned to a judge. As soon as it's filed, a judge has responsibility for that case.
That's like the federal system.
Like the federal system. And federal judges get along, you know, they sit in one place all the time. They get along fine. I really enjoyed sitting in Greensboro, where I knew the local bar. They knew me. I practiced law with them, and got along fine. And so I think whatever advantages that rotation may offer are far outweighed by the inefficiencies that that type of system creates, where judges come into a county, they really have no idea what they're going to have to deal with that week. They're presented with a calendar, and that calendar has been put together by the advocates, by the lawyers. I think we need to go more to a system where the judges control the calendars. I think that would create much greater efficiencies in the way we dispose of cases in the Superior Court.
And there have been some changes that have led in that direction. We now have narrowed the number of divisions and also have taken the calendar authority in criminal court and given the judges much more control over that than perhaps they had in the days when you were on the trial bench, when the DAs had full control of the calendar.
And I think we are moving in the right direction. We have reduced the number of our reduce the size of our divisions. I know that, and I think that's a move in the right direction. You know, and our district court judges, they don't rotate. They stay in the same district, and I think I think we need to let our Superior Court judges stay in the same districts more than they do, and not do as much traveling.
Some have argued that if we really want to be efficient, we need to not have so many districts, particularly in the rural parts of the state, combine more districts so that judges can handle cases over a wider geographic area, but can do it entirely in that area. In other words, not have rotation at all, but stay in a single district, but have the districts be a little larger. It's less of a problem, I suppose, in urban areas where the bars are large and
right.
The contact that you discussed when you were a trial judge, that the perception might not be good if you were too close to a lawyer, is less of a problem in an urban area.
It is, and that would also help in solving another inefficiency in our system, which is that our urban areas of the courts are extremely busy, but in many of our rural districts, we have court personnel there, judges and other personnel who are not busy enough.
Right.
And we need to rebalance that, and combining more rural counties into one district would help that. Good idea.
I want to take us to your years on the Supreme Court. You ran for the Supreme Court in 1976. Were elected, if I recall, and served first as an associate justice and later as chief justice. And during your time on the court, we're interested in a lot of issues. And not only did your work well day to day, but got involved in sentencing, as we've already mentioned, but in a number of other issues. And I want to spend a few minutes with you talking about, I guess, what it was that drove you to be involved in those issues, because not all judges do get involved in trying to improve the system. And I think if those of us on the outside looking at your career as Chief Justice particularly, but even as an Associate Justice, one of the hallmarks of it was your involvement in trying to make things better, make the system better, and to ensure its independence and its health. So talk some about why you felt driven to work on resources and independence and improving sentencing and the administration of justice and all the various facets that you did. What drove you to do that instead of just writing your opinions and going home?
Well, the seeds were planted for my interest in how justice is administered, really in law school. When one of the great deans of New York University Law School was Arthur T. Vanderbilt. Arthur Vanderbilt had been the Chief Justice of the court system in New Jersey, and he was a great innovator and administrator, and he actually transformed New Jersey's court system from what ours used to be, that is a hodgepodge of different courts with different jurisdictions, different selection methods all over New Jersey, into a very efficient unitary judicial system, as North Carolina later did too. Well, the spirit of Arthur Vanderbilt, he was not the dean when I came to NYU, but his spirit was very much in the halls of the place, and people talked about him. Our professors talked about him, and his portraits were there, and he had actually written a textbook on judicial administration, and I took a seminar on judicial administration there where we studied his text, and that's what planted the seed in my mind that it's not only important that courts do their fundamental jobs of deciding cases, but it's important that they do them promptly, that they do them efficiently, that they have the resources, that they have the organization that they need to promote efficient disposition of cases. This was where that idea was planted in my head. And so as a judge, this was something I always tried to do, even as a trial judge, tried to figure out ways to organize the calendars. If I would come into a county like Forsyth, for example, where I knew I was going to be for 6 months running, and we'd try to figure out, with working with the bar there, for example, I pick out Forsyth because I thought that was one of the areas where we really did a good job of reorganizing the calendars so that lawyers knew, say a month ahead of time what cases were likely to be heard. And we did that when I was on the trial bench. And then I carried over when I ran for the Supreme Court, North Carolina Supreme Court, and there was a vacancy on the court at that point. I had finished my first term as a trial judge. There was a vacancy on the court that had to be filled by an election, the only way it could be filled, because of the way my predecessor, Justice Higgins, Carlisle Higgins, and he planned it that way. He wanted his seat to be filled through the electoral process. So I did run, and in those days, judicial campaigns were, you didn't talk much about legal questions, you didn't talk much about the issues, political issues or philosophical issues of the day. Really, there wasn't much you could talk about, but at least we thought that you couldn't talk about much, but your background, your experience, and what you would like to do, and if you got elected. And so my campaign was actually sort of centered around some ideas I had for how to make our court systems better, more efficient. And that was sort of the fundamental thesis of my campaign for the court. And when I got there, I just sort of continued being interested in these things, how to improve sentencing, how to improve judicial organization, and just I talked about them at bar meetings when I'd be invited to speak, discussed them with our Chief Justices at the time. I was just an Associate Justice. Chief Justice Susie Sharp became Chief the same year I became an Associate Justice. We actually campaigned together, which is an interesting story in itself. And then Joe Branch succeeded her, and so we would discuss these things among ourselves on the court. But I was basically, as an Associate Justice, had no real authority to do much except speak to bar groups and express myself in that way about the need to have efficiencies in our judicial system, the need to have efficient organizations, more resources. But it was basically more just speaking. And then when I got to be Chief Justice, I had an opportunity to, push these things where in a more formal way, because that's the chief's responsibility. And again, when I ran for that office and I was elected Chief Justice in 1986, that was my basic campaign again. I've got these ideas, these are some things I think we need to think about in making our system better. Campaigned on that. And then when I became Chief Justice, I sort of said, well, you're not going to be able to do everything. You're not going to be able to change the world, so to speak. Let's just concentrate on 2 or 3 things. And what I tried to concentrate on was we needed to improve judicial salaries in order to attract more people to the bench. We needed to improve the way our judges are selected. The partisan political method that we were then using, and with which we had no real difficulty in the past, because judicial campaigns were not conducted along partisan or ideological lines at all. But the partisanship in the system actually began to rear its ugly head just about the time I was running for Chief Justice in 1986, and then even more acutely and I think more vigorously in 1990 when I ran for re-election as Chief Justice. So trying to eliminate partisan political elections for our judges And then finally, trying to persuade the legislature that we needed more resources, that the legislature had never really given the judicial system all the resources it needed in terms of technology, in terms of personnel. We were always, it seemed to me, short on assistant clerks in our clerks' offices, short on assistant district attorneys, and then when we got the public defender system in place, we needed more assistant public defenders. We just needed more people and more resources to do the job efficiently and well. And
so let's talk about a couple of those issues, and,
right.
and I want to start with the election system and how judges get to where they are to do the job that they try to do. And you're somebody who was appointed initially to the trial bench, but then ran and was elected to the Supreme Court at a time in which, had you lost, you would have given up your seat on the Superior Court, if I'm right about that. And then you ran for Chief Justice again in a circumstance in which you were in an Associate Justice's position and could have stayed there, but chose to run for Chief Justice. And so you sort of, your career was really made by the election system to a certain extent, and yet you've been someone who has supported an appointed judiciary for most if not all of your career. What is it about an appointed system that you think is better, that improves judicial independence?
Well, you're right. I was elected to every judicial position I held except my first appointment to the trial bench. But I never liked running for this job, running politically for this job. Contrary to the time I ran for the General Assembly back in 1966, I thoroughly enjoyed that campaign, because running for the legislature, you could have programs, you could have political ideas, you could have things you wanted to do for the people. But running for the judgeship, except for talking about judicial administration and how you might improve the court system, what are you going to promise? What are judges going to promise other than to be fair, to be thorough, to be efficient? Judges should not be thought of, it seems to me, as political beings answerable to the popular will. Judges are not anti-majoritarian, but they should be non-majoritarian. The guiding light for the judges is really what their understanding of the law is and how they apply that law to the cases that come before them and coming out with a decision. Many times judges are called upon to make decisions which are extremely unpopular with the people. Sometimes we're called upon to sometimes enforce individual rights that our laws guarantee. The Constitution guarantees them, statutes guarantees them. Sometimes case law says that individuals are entitled to certain rights that the majority of the people may not quite want them to have at various times in our history. So courts have got to be very sensitive to this. So it's always seemed to me that because of what judges are called upon to do, electing them and making them answerable to the popular will of the people is just really antithetical to the job we ask them to do. And judges should be completely independent. They should not, from the will of the people in doing their jobs, they shouldn't feel like that because they know they've got to make a tough decision that's going to be unpopular, that decision might come back and defeat them at the next election. And this has happened. It has happened. almost happened to me when I was running for both running for Chief Justice and running for re-election as Chief Justice, because of my views about the death penalty. You know, when I was in the legislature, I had voted against the death penalty. As a legislator, I had voted to abolish it in 1967. We had about 40% of the legislature in those days that were not in favor of the death penalty. And so my views on it were well known. And because I had voted in some cases, sometimes with the majority and sometimes with the minority, to give a new trial on a capital case or give a new sentencing hearing. When I ran for Chief Justice, my opponents, used these votes against me.
Even though you had also voted at times in the majority and in the minority to uphold the death penalty.
Absolutely. I had voted many, many times to uphold the death sentence, and constantly took the position that while, yes, I'm opposed to this law, I don't believe in capital punishment, I don't think it's good public policy, I still realize my duty as a judge to enforce the law, and I have done it many, many times as an associate justice and later as Chief Justice. But, for my opponents to come in and point out this case or that case, well, he doesn't deserve to be on the bench anymore because in this case or in that case, he voted to give a new trial or a new sentencing hearing. And this is just one example. We've seen across the country in states that have these partisan political campaigns for the judiciary, how single decisions, single votes on one or two cases have been used as reasons to defeat a given judge in those states.
And of course, the problem of judicial selection and its impact on judicial independence is one we still have throughout the United States. In North Carolina, we've made some changes toward nonpartisan elections and public financing of appellate elections. How do you feel about those changes?
Well, I think they're good changes. Raising money too was really raising money to run for the legislature is one thing, but raising money to run for judgeship was very distasteful. Asking lawyers or litigants to give you money when you knew that those lawyers were going to be appearing before you on the bench is something that judges ought not to be asked to do. Or be put in the position of having to do. So when I think North Carolina has made good strides when it, one, removed the partisan political nature of these judicial campaigns so that now judges run in nonpartisan elections, and two, when they went to the public financing system, which means that judges who participate in that system don't have to raise money. These are two improvements, but still they don't get at the heart. They don't get at the heart of the problem, which is judges having to go out periodically and face the people and campaign. You still have to campaign, and so I've never said that you can remove politics in our judicial selection process. I don't believe you can. Politics and judicial selection is like matter in the universe. It can't be destroyed. It can only be molded and shifted around and controlled maybe to some extent. You can't destroy it. There are certainly political considerations when you go to an appointive system. But and there are political considerations even in the federal system when the presidents appoint and the Senate confirms. We all understand that. But at least the politics are limited to the president's office or in the governor's office. They're limited to considerations by the Senate. So you're limiting, and in some ways the politics are just not running rampant among everybody.
And they're predominant in the selection process, not necessarily the retention process,
exactly.
Which I think others feel is important.
That's a very good point, Tom. The retention process is where judicial elections probably are the most troubling. Once a judge gets appointed to office or elected to office even, that judge should think and believe that as long as he is doing the job of a judge, deciding cases conscientiously according to the law, that he needn't fear being ousted because of the unpopularity of some of his or her decisions. And
So you, while you were Chief Justice, if my history is right, the judges in North Carolina did receive a salary adjustment, and to my knowledge, it's certainly in my judicial career, it was the only time it happened, and I don't think it's happened since. In addition, the courts did receive additional resources that they hadn't received before through your diligent efforts. So you accomplished many of the things that you had on your list when you first became Chief Justice. Tell us,
well,
what was
we made some improvements.
Made some progress.
We made some progress. We never did get it totally like we wanted it,
Right.
but we made some progress.
Tell us what was the most rewarding part of being Chief Justice of North Carolina?
I think, well, I can't single out one thing. Let me just say several things. First of all, one of the most rewarding parts was helping to persuade the General Assembly in a couple of sessions that we really did need more resources, and I never was able to make much progress on judicial elections. I did ask the General Assembly through appropriate channels to give me an opportunity to come over and address them. And I think I was the first Chief Justice to make a State of the Judiciary address to the General Assembly. And I continued that throughout my 8-year term as Chief Justice. So being able to go over and speak directly to the General Assembly about these things that were of concern to me and others in the system was a great reward in and of itself, and to have them respond, at least with regard to the resources issue and the salary issue, was big and satisfying. The second thing I would say would be one of the most satisfying things was just the people I had to work with. You know, the justices, my colleagues on the court were such terrific folks. I remember them all so fondly. We had a very collegial court at the time. It was just really rewarding to work with them in crafting our decisions and crafting our opinions. The members of our court were very independent-minded, and it was hard sometimes, if you disagreed with one or more of your colleagues, to go to them and persuade them that maybe they ought to change or shift their emphasis or something in an opinion. And occasionally when you would succeed in doing that, that was a tremendous personal reward. And then, they would also come to me and say, persuade me sometimes to change. But getting your opinions done, feeling like you had put together, crafted an opinion that made some sense, that moved the law forward in a way that you felt was salutary and good for society, was a very satisfying aspect of the job. I felt like in one area of the law that I felt like my opinions contributed to particularly was in the area of workers' compensation and chronic obstructive lung disease, the way in which these This was a big thing in North Carolina, being a textile state, and a lot of our employees, at least in those days, were working in the textile industry, and these problems with their breathing caused by cotton dust in the mills, or at least what the contention was, gave the courts a lot of trouble for over a decade. And we finally, I think, on our court while I was Chief Justice, crafted a body of opinions that helped make some sense out of these cases and gave some, I thought, reasonable guidance to the Industrial Commission and to the bench and bar, and indeed the industry, about how to go about processing them. That was a I thought, an important and satisfying event.
It's been about 10 years since you left the Supreme Court. You've been vigorously practicing law and appearing before the Supreme Court, arguing appellate cases. An incredibly distinguished career as a lawyer, legislator, trial judge, appellate judge, Chief Justice. Looking back, as you must on occasions, have there been any regrets? Did you make any career decisions or moves that you would second guess at this point, or any advice for people who are 31 and thinking about their career?
I don't think so. As far as my career decisions, it may be that I got started in this job a little early, and got started in my judicial career a little early. And if I had it all to do over again, I might wait until a little later in my legal career to do this. But then on the other hand, you have to take these opportunities when they come along. And I had the chance, and I might not have had it later on. I do regret that I was never able to make much progress on the judicial election front with the General Assembly. As hard as I tried, I really devoted a lot of energy to that, and could not make much progress with that, and that was a regret I had.
But you're still working on it.
I'm still working on it. I'm still a member of the Bar Association committee that's trying to work on that. One thing that helped me sort of assuage my disappointment in this area and other areas. While we made some improvements in judicial salaries and judicial resources, again, I never was able to get them quite where I wanted them. And we never made a whole lot of progress in changing the organization of the judicial system. But we at least, the thing that I was proud of was appointing the Commission on the Future of Justice in North Carolina. That was one of the last things I did as Chief Justice, was to set up, I thought, a very nicely composed commission. It was chaired by John Medlin, who was CEO of Wachovia Bank at the time, and a number of judges, some lay people, and charged with the idea.
Co-chaired by former Chief Justice Rhoda Billings as well.
Right, co-chaired by former Chief Justice Billings. The charge of this committee was to really dig deep with no holds barred. I didn't put any currently serving members of the judiciary on the committee, as I recall, because I wanted them to really look at the system critically and just recommend to the bench and the bar and the legislature what they thought honestly needed to be done to make the system better. And I think they studied for about 2 years. They came up with a very fine report, which basically contains just about all of the ideas that I ever had for what we really need to do to make our system what it really can be.
And in fairness, Some of those have been actually implemented. There's now a judicial council, there's a family court. There are a lot of changes in our system that have occurred as a direct result of that Futures Commission. And many of the ideas are still debated. The question of more budget independence in the judicial branch and a number of other items that were recommended by that commission continue to be debated, and I know you continue to be a part of that debate. And in fact, I hope you'll join me later, maybe in January. We're thinking about having a new look at the Futures Commission report and where it should go from here, what's been accomplished and what happened, and I may have you join us at that and lead that off. But thank you for being with us today, and I'll give you the last word to say anything you might to members of our profession and to young lawyers particularly about your career and what it's meant to you.
Well, thank you, and I agree with you that we gradually are enacting recommendations of the Futures Commission, and I hope that process continues, and I'll be glad to help you with it any way I can. You know, looking back on my career, I'm very thankful for the confidence that people showed in me along the way for whatever reason, deserved or not. You know, Governor Moore showed a heck of a lot of confidence in a 31-year-old lawyer, pretty much unproven. And then to have the support of the people of North Carolina, I guess it was four statewide elections. First to be reelected as Superior Court judge, and then to be elected to our state's highest court, and then to be elected as Chief Justice by the people of this state was just really more than I probably deserved. And I'm very grateful for the support that the people showed me, these sort of turning points in my career. For young lawyers, you know, you sort of, I never was one to have a grand plan for my life. I never started out thinking that I would ever be a judge. And certainly not a member of our Supreme Court, and certainly not Chief Justice of our court. I mean, that was, those thoughts never entered my mind as a law student or as a young lawyer. You know, I just tried to take it day by day as the cases came along. Applied myself the best I could, worked hard, worked regularly, tried to treat other lawyers with respect and with courtesy. The legal profession and our judicial system are really the only place where serious disputes can be resolved according to rationality, according to neutral principles of law, where people, lawyers and clients, particularly lawyers, being the champions of their client, and given this great privilege to go into our courts and contend for their clients, need to always keep in mind that you know, there are two sides, and lawyers should never lose sight of the fact that both lawyers on both sides are essentially doing the same thing. They are representing their clients. And this dispute that they have, that they bring into our judicial system, or indeed that they have in their offices, and the lawyers communicate with each other every day, personally and not in the context of a courtroom. But lawyers on the other side we're all part of the same profession. We're all in the same boat. And we have a duty to treat each other as professionals, with respect, with courtesy. And when a lawyer says something to you about what he's going to do or not going to do, there should be no question about your ability to accept that and rely on it. We need to be scrupulously honest with each other in our professional dealings. Work hard, be a good fighter, but fight fair, and fight with rationality and understanding that we're all in this together, we're all doing the same thing, and we can disagree without being disagreeable.
There are those that would argue that democracy depends on that really what separates our country and our democracy is our ability to resolve disputes in a peaceful setting under the rule of law, and that the legal profession really is the embracer of that and must hold it dear and must protect it. And one of the ways you do that is through ensuring that disputes can be resolved with courtesy and with respect, and not elevating to levels of violence as happens in other countries.
Well, absolutely. I mean, our judicial system and our legal system have been the underpinning, in my view, of our democracy. It's what sets our democracy apart from most other countries in the world. Our system and the system in England, where our system came from, but it rests on this bedrock idea that there is a way to resolve extremely important disagreements calmly, rationally, and with courtesy and respect for all involved.
And you have protected North Carolina and her role in democracy for many years as a leader of our court system. For that, we are eternally grateful as lawyers, as people of this state, and we thank you.
Well, thank you, Tom.